e kea a kaha ho kolo kolo ki e hano hano ua a koa koa ho maila. This Honorable Supreme Court is now reconvened.
All right, please call the case.
SCWC-17-00006, Peter J. WINN and Westminster Realty, Inc., Respondents, Plaintiffs, Appellants, versus Wade Brady et al., Respondents, Defendants, Appellees, and James E. Spence et al., Petitioners, Defendants, Intervenors, Appellees, and Stephen R. Spence et al., Respondents, Defendants, Intervenors, Appellees. Aaron Munn arguing for the petitioners, Lance Collins arguing for the respondents. Argument on the merits.
All right, good afternoon. Aloha, everyone. Proceeding today is being broadcast live on the Judiciary's YouTube channel, as well as on Olelo. I want to welcome our substitute justice, Judge Peter Kubota, joining us from the Big Island. Thank you, Judge Kubota, for being with us today. The way we'll proceed is during the course of today's argument, should the justice have a question, they'll raise their hand virtually and I'll call upon them at the earliest opportunity. Right now, I'm going to ask our attorneys to introduce themselves in the order in which they will be arguing.
Good afternoon, Chief Justice Rector Wald, Justice McKenna, Justice Devins, Justice Edens, and Justice Kubota. My name is Aaron Munn, and I will argue on behalf of petitioners James Spence and Beverly Spence.
All right, thank you, Mr. Munn. Mr. Collins.
Aloha, good afternoon, Chief Justice and Associate Justices Lance Collins for the WINN respondents.
All right, the court's allocated an hour for oral argument today. Mr. Munn, you indicated you wanted to reserve 15 minutes for rebuttal, so we'll give you a warning 15 minutes into your argument. Mr. Collins, you'll have 30 minutes. We'll give you a warning with 10 minutes to go. And you'll know that you're at the end of your allotted time. You'll see a light and you'll hear a bell in the background. So that's how you'll know. Mr. Munn, please proceed with your argument.
Thank you, Chief Justice. So there are several important questions on this appeal, and I think it would be a good idea to begin by simplifying the issues on this appeal. The first issue is whether a recorded judgment lien is a property interest. Now, we don't dispute. The second issue is whether a lien holder entitled to notice that comports with due process. Again, we don't dispute that general proposition. A third issue is, can the ICA effectively rewrite what is otherwise a plain and unambiguous statute? The answer is no, and I can get back to that if the court would like. But the most important question on this appeal is whether the ICA's new rule should be applied retroactively against the Spences 9 years after they reasonably relied on the statute in favor of Peter WINN. The answer is no because of fairness. And what do I mean by fairness? Well, essentially, Peter WINN is asking this court for something he himself did not do. Specifically, WINN complains that in 2015, when my clients conducted an execution auction on the Haleakala estate property, they did not give him personal notice of the sale, even though he was a judgment creditor of record. However, what WINN does not say is that 2 years earlier, in 2013, he himself conducted an execution sale on a different property, yet he did not give my clients personal notice of that sale, even though they were judgment holders of record at the time. It all comes down to fairness, and it's the golden rule that we were all taught in high school. Do unto others as you would have them do unto you. In this case, he did not do that. The ICA abuses its discretion by retroactively applying its new rule against the Spences. Now let me talk about retroactive application. This court, in numerous cases, but I will cite one, State v. Ikizawa, 75 Hawaii 210, has set forth 3 factors with respect to whether a new law, a new rule should be applied retroactively. The first factor is the purpose of the new rule. And this court has said retroactive application is generally proper with respect to rules designed to protect the very integrity of the fact-finding process. In this case, that is not present. This new rule, it was designed to give notice to the holders of record. It has nothing to do with the fact-finding process. The first factor does not support retroactive application. The second factor is the extent of their reliance on the old rule. And in this case, it was substantial. As I mentioned before, my clients reasonably relied on the plain and unambiguous language of the statute 9 years ago.
Mr. Munn, we've got a question from Justice Devons, followed by Justice McKenna. Justice Devons.
Thank you, Chief Justice. Mr. Munn, on that question on application of this, what you cited as a new rule, what has happened to the property since all of this has been pending? In other words, was there any construction? Was there improvements? Who lives on the property?
So thank you, Justice Devons. So the execution sale took place in 2015. Since then, my clients and I believe James's brother, Stephen, and his wife, Valerie, all four of them own the property to this day. Stephen and Valerie continue to live on the property to this day. Also, since 2015, substantial amounts of money and time have been gone into this property. It's not in the record, but in 2020 or 2021, there was a fire and they put a lot of money into improving the property, paying off the mortgage.
There's a house on the property from what I understood?
Correct.
Okay, and so it hasn't changed hands since then, though. It's still in the four parties' expenses,
That is correct.
ownership.
Yes.
Okay. But since the initial sale went through, it did change hands a couple of times, right? Nohara got bought out, and then it went from Haleakala Estates to, then they bought out Nohara, they got 100% ownership, and then it got divided up where it is today. Is that a correct understanding?
Correct. That is right.
Okay. Let me ask you, you said that the court was rewriting 636-3, but they haven't touched 636-3. They're just saying there's an additional due process notice requirement, which requires personal notice when it's reasonably able to do so. Isn't that really what the court said?
So I think the statute's 651-43.
I'm sorry, correct, I'm sorry.
No problem. I think you're correct. The ICA was very careful not to explicitly rewrite something into the statute. But if you look at what they did, that's essentially what happened. The statute's clear and unambiguous. The statute provides what notice a party has to go through and provide when executing on a property. There's no exceptions.
Right, but that's not notice for someone that has a property interest. They're saying if you have a property interest, you have to try and serve the person personally. Because you have the Shin case that says there's an automatic lien that's created in the real property, and you have 636-3.
Right, but I think it's a little more complicated because in some of those other cases, what the ICA did or what the court has done is declare the statute unconstitutional, either on its face or as applied. In this case, the ICA avoided that question. So basically, they don't want to engage in they didn't engage in statutory interpretation. There's nothing to interpret. They don't want to rule that it's unconstitutional. What they did was just create a new rule.
Well, they recognize the property interest. That's what's triggering the personal notice.
I understand that. I understand that, Your Honor.
Thank you.
Justice McKenna.
I'm sorry, I don't have a question. It's just a technical issue. Could we ask that everyone that is not speaking turn off their microphones because we're getting a lot of feedback and noises. I appreciate that. Thank you.
We'll keep an eye on that. If it becomes still Justice McKenna or anyone, let us know.
It is an issue we keep getting like noises and feedback.
Yeah, hopefully we'll stop now. All right, please continue with your argument, Mr. Munn.
Thank you. So continuing on with the second factor regarding retroactive application is compliance. Here, my clients unquestionably complied with the statute. They hired a process server, Chris Williams, in fact, the same process server that Mr. WINN hired when he conducted his auction 2 years earlier. And he complied and exceeded the statute. He posted in 4 places where the statute required 3. And there's also reliance by others, countless others who have relied on the statute for the past 9 years. Third and final factor regarding retroactive application is the effect on the administration of justice. And this is grave. There's, like I mentioned before, there's clear prejudice to dispenses. It would open the floodgates to litigation. And lastly, it would conflict with the confirmation order. The record shows that in a separate case, my clients executed on a property, it went for confirmation hearing, and the court issued an order confirming it. That order was never appealed. That order stands today. What Mr. WINN did was, in a different case, obtain an order from the Second Circuit, which was eventually reversed. But the effect of the ICA's decision is to create two conflicting orders. It would also allow, an affirmance of the ICA's decision would also allow Mr. WINN to effectively jump the line. Whereas 9 years ago, he was a junior creditor on a unimproved property. If the ICA's decision stands, he's effectively a senior creditor on a much more improved property, giving him a windfall. Now, why is that important? Why is any of this important? The Supreme Court has said, implicit in the factors regarding retroactive application is the concept of fairness.
Mr. Munn, we have a question from Justice Devens, and Judge Kubota, you're not showing up as muted, but I understand you are muted. So again, just trying to make sure we have the audio as clear as possible. Justice Devens.
Can you hear me? I disabled my microphone.
Okay, very well. I think we've done everything we can at this point to keep the audio clean. Justice Devens.
Yeah. Counsel, I apologize for interrupting, but that Colepa property sale, I thought from the record that the property, Brady didn't hold an interest at the time it was sold, that it had been transferred to a trust, but it wasn't in his name. So therefore, I would think that you wouldn't be entitled, or your client wouldn't be entitled to notice in that case. But let me ask you, what, in trying to get to this prejudice argument that you're presenting, what do you see happening if we have to unwind everything from here, if that's where this ends up?
Well, I think
and I mean, as far as a prejudice to your client, to clarify.
I'm sorry, the question is what would I ask the court?
If we have to unwind all of this at this point, what's the prejudice to your client? What do you see happening?
Well, if the court affirms the ICA, I would see Mr. WINN executing on their interest, their 50% interest on the property, being able to outbid them because of his, I don't know how much money the judgment is at this point, but it's a substantial amount. And our clients would effectively have to pay him off rent. I don't know.
What happened to the mortgage liens that were senior to all of this?
My understanding is one of them was paid off.
Right, that was through Nohara, right? Mr. Nohara.
Correct.
And there were two liens on his side.
Yes, and I think the other one, the family, I don't know the specifics of it, but the family is taking care of it jointly.
Thank you.
Justice McKenna.
With respect to due process, I think we have indicated that it is process that is due under the circumstances. And in that regard, you just said one of the first mortgages was paid off, but was that after or before your execution sale?
That was after, Your Honor.
All right, so here's my question. At the time of your execution sale, you were obtaining a 50% interest, right, in the property, subject to the first and second mortgages, right? Is that correct?
That is correct.
What was the fair market value of the property at the time?
So there's evidence in the record that it was about $800,000.
The fair market value of the property was $800,000?
That's as far as I could tell.
The
We didn't get
50% interest, the entire property, or the 50% interest?
the entire property.
$800,000, and it was subject to mortgages totaling almost 1.2 million at the time?
That was the mortgages of record, Your Honor. And like I said,
I see. So we don't know what the principal amounts were at
we
the time.
don't know, and also, we didn't obtain an appraisal of the property either. That's just what was in the record. I think there were Zillow, references and whatnot, so it wasn't official fair market value.
Okay, so we don't know what the outstanding balances were on the first and second mortgages at the time of your execution sale of the 50% interest.
That is correct.
And did Mr. Nohara receive any notification of this sale? Your sale?
Yes, Your Honor. We posted notice on the property, and I believe his wife showed up at the execution sale.
I see, it was her. Somebody bid like 2,500, right, initially?
Yes. That's
Was
correct.
that your client, or no, it was her at the time?
It was Ms. Nohara
I see. And then you paid $25,001
at the confirmation hearing.
confirmation. Okay, thank you.
Mr. Munn, I think Mr. Collins argues that there's really not a new rule here, that principles of personal notice to folks with an interest have been well known for a long time, both in Hawaii and of course at the federal level with the Mullane case. What's your response to that argument?
So we're not disputing that due process exists or that due process requires notice that's reasonably calculated under the circumstances. We're not disputing that. Obviously, we think that the statute did provide for due process in the first instance. But the real issue that we're arguing today is this notion of due process and this extra requirement that the IC articulated should not be retroactively applied against my client and in favor of his, especially because he did not do what he's asking the court to rule in his favor. And
his argument is it's not a new rule. It's a well understood principle of due process that personal notice has to be given to folks with an interest in a particular property, I guess, and and I'll let him articulate the argument, but that it's something that should have been anticipated. What's your response to that?
Well, it is a new rule in Hawaii, and I understand the body of case law outside have articulated that rule, but until this IC opinion, no court in Hawaii has articulated that. There's no way my clients could have anticipated that.
Very well, thank you.
Okay, and this is a very important point. I believe Justice Devins brought this up.
Well, Justice Devins has a question, Mr. Moon.
Oh,
Justice
okay.
Devins.
Yeah, I'm sorry. As far as, you saying that, the due process requirements and Mullane and, under reasonable circumstances, but in this case, didn't your clients have contact with Mr. WINN? They had been in communication with him. They knew where he was. They knew how to get in touch with him. So that personal notice could have been served if it had been pursued?
Yes, Your Honor. Personal note, there's nothing stopping personal notice in this case. That goes both ways too, with Mr. WINN and his option 2 years earlier. But you're correct. Nothing was stopping.
Except the Kalepa property wasn't in Brady's name at the time. So why would your client be entitled to any notification for that sale? Now, I know you're making the argument, but I was just wondering why.
So I will address that right now. Mr. Collins and Mr. WINN have argued, as you point out, that there were these deeds years before that auction, and that is why our clients were not entitled to notice. But let's look at those deeds. The first deed is at record 164. That's dated December 16, 2010. And I would say if you look at the deed, you look at the face of the deed, it is of questionable effect. So let me go to 164. 1 second. Record at 164 is a warranty deed. Front and center on the warranty deed is a note from Title Guarantee. It says, Title Guarantee of Hawaii has filed this document for record as an accommodation only. This document has not been reviewed or in any way examined as to its effect on real property. That same exact note appears on the other deed, which is record at 157. Now, I don't know what the issue is with these deeds, but apparently Title Guarantee had an issue, and the issue was big enough for them to put this note on the face of the deeds. The second point I would make in response to Justice Devins' point is If Mr. Brady did not have any interest in this property because of these deeds, then why hold the execution sale 3 years after these deeds are dated? Why show up and pay $200,000 for that interest? It just doesn't make sense. The return of the writ of execution by Chris Williams, the guy that Mr. Wynn hired, says, and I quote, on August 13, 2013, Christopher Williams auctioned off 50% of the undivided fee simple interest in the property located at 2806 Colepa Place, held by Wade Brady and Catherine Brady individually. So to say that they didn't have any interest at the time of that sale, I think is wrong. Third, and the last point is, if you look at these deeds, both of them are dated the exact same date, January 4th, 2011. Well, the record shows that my client got a judgment against Mr. Brady on October 2010. That's a month and a half before these deeds were supposedly executed in favor of Mr. Wynn. A month and a half after my client got a judgment. That's a clear case of fraudulent conveyance, assuming these deeds are legit.
Thank you, Mr. Munn. We have a question from Justice McKenna.
Yeah.
Oh.
Yes. I understand you are now raising, you're saying that Mr. Collins' clients, the Wynns should be precluded from not doing what they didn't do, correct? In terms of the other property that they didn't give you notice, correct?
Correct. That is correct.
But first of all, when they executed on the other property, they could only execute subject to your judgment lien, right? How could your prior judgment lien be erased by their sale?
That's a good question, and I don't know the answer to that. But if you look in the record, their judgment purports to erase our judgment from the record.
I see, because it wasn't a mortgage, it was a judgment lien, so.
Right, so.
I see.
Yeah.
Okay, so you're basically raising an estoppel type of theory on cert, is that right?
So it goes to a lot of different theories. It's judicial estoppel, absolutely. It's the issue of fairness, promotion of justice, which the court is bound to provide.
Well, what about quasi-estoppel? We have held in several cases that the doctrine of quasi-estoppel is a doctrine in which a party is stopped from taking a position inconsistent with a previous position if the result is to harm another.
Absolutely, Your Honor. I think that's what I was talking about with judicial estoppel. I think they're probably called the same thing, but that's essentially what I'm saying.
And I think judicial estoppel is actually a different theory, but I understand. Thank you.
But the point is, this issue of fairness goes to a lot of different legal principles.
Mr. Munn, we may have a question from Judge Kubota. Judge Kubota, were you trying to ask a question? If so, please go ahead.
Mr. Munn, now this execution process, of course, is different from a regular mortgage type of foreclosure or foreclosure on a judgment. But in proceeding on this execution, don't you go through your due diligence of getting a litigation guarantee, which would reveal the subsequent judgment by WINNs? And then why wouldn't you just serve the junior lien holder and avail yourself of the statute to basically clean them off of the property?
Thank you for that question. It's a good question. We follow the statute, and to be honest, we hired the process server that has been doing this for years on Maui. Like I said, the same process server that Mr. Wynn hired, and we relied on that. We relied on the plain language of the statute, and we relied on his experience in doing it.
But question again for you, don't you folks, as a matter of course, get a litigation guarantee on the property that you're executing upon? And that would reveal the other judgment holder. And there's some indication that your client spoke to the WINN party, but there is a recorded judgment on the property you're executing on. Why not serve them? Because you're going to court anyway. And then you would avoid this whole issue of lack of service and quashing their due process rights.
To answer your question, we did not get a litigation guarantee. And I, other than what I've said, I do not know why we did not give a personal notice.
All right, thank you.
Mr. Munn, we're in a bit to your rebuttal time, but if you want to continue with more points for the court, or if you want to wrap up now, it's totally up to you.
Give me a second. I think I will reserve the rest of my time. I don't know how much time I have remaining, but I will reserve it for rebuttal.
Like about a little over 7 minutes, so.
Okay, I'll take it.
All right, you got it, Mr. Munn. Thank you for your argument. Now we'll turn to Mr. Collins. Mr. Collins, your argument.
Aloha ai olo olo ai ka'aha ho kolo kolo kie kie. Aloha, and may it please the court. The Intermediate Court of Appeals rightfully recognized that those with a recognized property interest are entitled to notice before that interest is extinguished. A recorded judgment is a protected property interest protected by due process, and it has been since 1913. An execution sale is a state action as it exists entirely as a judicial process. And finally, the Intermediate Court of Appeals recognition of the property interest that inheres in a validly recorded judgment is not a new rule, but at most a clarification of longstanding existing law. And to the extent that this court is to consider that the ICA's decision is a new rule, there's no justification for applying the purely prospective type of application of this rule in this particular case. With respect to whether the ICA's decision is a new rule, this court in Raposo versus State 150 Hawaii 66 said that there are 4 guiding principles in determining whether or not case law has created a new rule. The first is that the prototypical manner in which this court creates a new rule is when it overrules a previous decision and announces a superseding principle of law. That does not apply in this case. Second, is another classic situation in which the court establishes a new rule when it announces a new principle of constitutional law. That is also not applicable to this case. Raposo goes on to say that in instances where the court engages only in statutory construction to elucidate the meaning and application of specific provisions of a statute, that a new rule does not arise. And the new rule also is not created where the court merely clarifies existing legal principles. In this case, our position has been that the WINN parties were entitled to notice that their property interest was going to be extinguished, and that is not new law. HRS 651-43 has to do with the advertising of an execution sale. The statute reads, "The officer shall, after levy, advertise for sale the property levied upon." It doesn't say that this statute is not a statute saying anybody with a property interest in property to be executed needs to be given notice. It's simply a statute that describes how the executing officer is to advertise the sale. And what is the purpose of that? It is to give the sale legitimacy as though it was being conducted on the open market. That's the sole purpose of advertising for a sale, is to try to get the highest price possible in the sale.
Mr. Collins, we have a question from Justice McKenna. Justice McKenna? Well, I think you're muted.
Thank you. I'm sorry. I'm trying to think this through, Mr. Collins. Your client, the execution for the levy on the property was accomplished through an ex parte motion for execution sale, correct?
Yes.
And that was because this was a default judgment, correct?
Yes.
And under the Rule 7, if a party is in default, you no longer have to serve papers, etc. Correct?
Yes, generally true.
But don't we also have case law indicating that even if a party has been defaulted, you do need to provide notice if they're still entitled to be heard with respect to the damages portion, even if there's a default on liability.
That's generally correct. Or there has
So
to be a hearing at least. Yeah.
Right. So I'm wondering whether that cuts in favor of your client's interest here. In other words, even when there's a default on liability, parties who have been defaulted are basically entitled to notice as to the amount of damages. And I'm wondering how that might relate to this situation, which is like amount of, I don't know, potentially relates to the damages of your clients. But that was not analyzed. You haven't argued that, right?
Well, Your Honor, I would just say that as far as I understand it, Mr. Tilley, who's the trial court attorney in this case, I think within the last year renewed the judgment in this case. And as far as I know, Mr. Brady did not raise any of those issues as to the renewal of the judgment. So we haven't briefed it, but in terms of practical effect in this case, the person that would have standing to raise that, I think has, at least in the last decade, has not raised it. So
okay. But here's another question to you. How do you respond to the arguments regarding estoppel, whether quasi-estoppel or judicial estoppel or any form of estoppel? Why should you be able to take benefit? Why should we credit your argument here when you didn't provide notice on a previous execution sale?
Well, Your Honor, I think the first part of that is that the circuit court actually didn't make findings about that. I think the record is somewhat incomplete, and no cross appeal was filed regarding the circuit court not making findings about that. And the ICA, in a footnote, noted that, in fact, that had not been raised by the Spences. And so our position is that we don't believe there's a quasi-estoppel issue with respect to that, but the record we don't feel is complete, and there weren't findings. The circuit court declined to rule on that point, and the Spences didn't take that up as a cross appeal.
Thank you.
All right, Mr. Collins, we have questions from Justice Devens, followed by Justice Edens. Justice Devens, your question.
Counsel, part of your argument is that had you received notice, your clients would have been able to participate in the sale. If they had participated, how would that have changed the outcome, given that 65143 is the notification for the sale of the property? But how would it, if they had participated, how would that have changed anything?
Many possible different things could have occurred. I think one preferable future, alternative future for Mr. WINN and Westminster Realty would be that he would have become the successful bidder at that sale and would have taken the property and engaged in a partition action, and either would be the owner of that property now or would have gone through the partition sale process and would have moved on to his next venture.
Well, they had filed the amended judgment back in 2013. And then I understand Catherine Brady files bankruptcy in April of 2013, but the stay was lifted by June of 2013. That was only 2 months later. But your clients didn't move forward with anything until 4 years later. What was the reason for not moving forward when they got the previous judgment? They seemed to move right away on the Palepa property. What were they waiting on? Was it the senior mortgages that were there, or what was it? I'm just curious.
Yeah, Your Honor, I don't specifically know as to the exact timing of it, but I do know that Mr. WINN and Westminster Realty are business people, and there might be a number of reasons. When I engage in collections, which is very far and few between in my cases, sometimes the collections don't occur until the 9th year. In fact, I just renewed a judgment in the First Circuit where my client only got $500 in the first 9 years and then got $15,000 in year 9.5. So it's something that, I mean, that's why a judgment is good for 10 years, because sometimes you can't immediately collect on a judgment. Why the specific reasons that there was a wait, I'm not entirely sure, but there was a mortgage on the property and he was a junior liener. So I can imagine that maybe he was waiting for the right time.
Right, but in the reply brief that you filed, you were trying to explain the delay was due to the bankruptcy, and it was not until September of 2016 that your client was able to move forward. But it was really back in 2013, June, that the stay was lifted as far as allowing your client to move forward. So it wasn't the bankruptcy stay that kept him from executing.
Yeah,
Am I
that, Your Honor,
correct in
I'm not sure
understanding
why.
the record?
Yes, yes.
Thank you.
All right, Justice Edens has a question. Justice Edens?
You know, you say this is a clarification of longstanding law, and you know, I'll agree with you on the longstanding law. I mean, 651-43 has been around since 1859, unaltered since 1886. You know, but this was an execution sale 9 years ago. Mr. Munn argues that they relied on the finality of the confirming of the sale, and they argue they suffer substantial prejudice due to the retroactive application. What's your response to their position that they are suffering substantial prejudice?
Well, I think the first thing is that, I mean, this is why we have adjudications, is to determine what the law is. And so with respect to the retroactive application of quote unquote a new rule, I think if you look at Ikezawa, the reason why that was purely prospective was because the court in that case said that if Ikezawa had merely delayed the filing of his motion, which had brought the matter up to the Supreme Court by a few weeks, then he would have been subject to a different interpretation of the penal code and would have had the relief that he had. And so in that case, they said they were going to make it purely prospective so that Ikezawa would not be harmed by that. But that
isn't there, when you're talking about retro, that's in the criminal context. So is there a difference? Can't there the argument be made that we are going to give criminal defendants the benefit of that type of an application to a new rule versus a civil context? And I would still like to hear your answer about substantial prejudice. Maybe you're conceding there's substantial prejudice, but is there anything else aside from Raposo or the Ikezawa case that you want to make a point on before answering the substantial prejudice question?
No, Your Honor, we don't believe that there's substantial prejudice. This is part of the litigation process, and if you fail to comply with the notice procedures that are required, this is the result that should happen in a civil case. And I would just, by directing the court's attention to...
I mean, Mr. Munn says, I mean, we did what we were told to do under the statute. And so to suggest that that is not complying with the law, I'm finding that somewhat difficult. Now, you had made the statement that, you know, it was almost, I forget exactly what you said, but it was almost implicit in the law. We've already sort of decided that. But how is somebody like Mr. Munn's client supposed to know that?
Well, for property transactions, I think something that's considered to be the standard is to look at the title report. And the title report noted the fact that there was this junior judgment. So that would be the first indication that perhaps because this thing is on the title report, that there needs to be some heightened level of notice. I mean, I think that's sort of on the level of common sense as opposed to some specific principle of law. But I want to go back to a moment in terms of substantial prejudice. There are cases where in the adoption of children, a party does not comply with ICWA, the Indian Child Welfare Act. And years after a child has been adopted and has bonded with a new family, they're ripped from that family and everything starts over from scratch because proper notice was not given. I would consider something along those lines to be extreme substantial prejudice. But in those cases, the child has to go back everything is undone back to the point where notice was not given. And it starts over again at extreme prejudice to the children that are involved. And that actually happens anytime a termination of parental rights occurs. Doesn't have to be in the ICWA context. There's substantial prejudice to children. But that happens because that's part of the due process that parties are entitled to in that context. So it's a liberty interest, not a property interest. But in that context, it's like case after case that happens all of the time. And that would be an area where if we were going to apply the purely prospective application of notice requirements, those would be the first candidates to take a look at in terms of trying to parse out the impacts on the people involved in the case. Where this is a matter of people extinguishing each other's property interests through execution sales, I don't see there being substantial prejudice to the parties. This is a piece of property. They're not entitled to have it because the way that they got it was improper. They had actual notice of the people that should have known. It was on the title report, and they just didn't comply with the law. And that's part of the whole process of property and money judgments and stuff, is you have to follow all the procedures. And if you don't, then you go back and it gets sorted out in the way that it's intended to by law. So that's our argument with respect to substantial prejudice.
Mr. Collins, we have a question from Judge Kubota and then Justice Devens. Judge Kubota.
If there was a title report done, but you heard me questioning Mr. Munn regarding a litigation guarantee or title report, which they said was not received. So they do not have a title report that you refer to. Comment quickly, because I have another question regarding what you seek as your remedy here.
So there was a title report. It's at page 437 of the record. It was attached as Exhibit G to the Spence's ex parte motion for the first alias writ. It's a copy of it as an exhibit to an exhibit.
So there was a title report at the time of the Spence execution, which revealed your judgment lien. Is that what you're saying?
Yes. Yes, Your Honor.
All right. So maybe Mr. Munn's answer was just regarding to a litigation guarantee. So there was a title report.
Yes, that's correct.
Okay. Now, if we affirm the ICA decision here and apply this interpretation of the statute and due process requirements retroactively, Justice Devens asked you, what would you have done then? What is the result now, though? Now that we're 10 years down the road, a mortgage was paid off, the other Spences somehow bought the other 50% interest. So you folks are looking to have a chance to execute on your judgment and purchase what was formerly the Brady 50%, and you're going to be a co-holder with the other Spences?
That might be an intermediate step. Of course, reasonable people could always resolve the case on remand so that it doesn't require the circuit court having to make any further decisions. There's many things that could occur, but yes, it would basically unwind things to the point where the WINN judgment has not been extinguished against the property. And there have been changes. And so if the circuit court were required to make determinations, they of course would have to take all of those factors into consideration.
Okay, sorry, one last question, if I may, Mr. CJ. This execution statute 651-95, from my practice a long time ago, we never, we considered it basically a quit claim type of sale. But 651-95 in the same statute provides that the sale shall operate to extinguish subsequent liens and encumbrances, and without forcing the prior lien holders to their right of recovery. That tracks pretty much the foreclosure statute, which cleans out junior liens, and no one has mentioned that. So what's your comment on the application of that section, 651-95?
Well, Your Honor, I think that it's the same principle applies that before something can be extinguished, before a property interest can be extinguished, that the party who holds that property interest has to be given a notice and be given the opportunity to take steps to protect their interest as much as possible.
All right, thank you. That is all.
Counsel, if I can quickly ask you, would you agree that Mr. Munn's clients fully complied with 651-43 and posting the minimum 3 notices? In fact, I believe they posted 4, and they did that in good faith. Would you at least agree with that?
Yes, we don't disagree that they complied with the plain language of the statute.
Okay, and the IC's decision, is that the first time that a court in our jurisdiction has articulated this rule that recognizes the property interest right and talks about the personal notice attaching to the such rights? Is that the first time it's been articulated, at least here in Hawaii, as far as you know?
Well, our position is that the Shin case previously has identified that a recorded judgment operates as a lien against all real property in Hawaii. So we don't feel that it's exactly the absolute first instance where appellate court has ruled on this point, but it has clarified that principle with respect to this advertisement notice statute.
Did Shin discuss personal service of notice?
Shin did not.
Thank you.
Mr. Collins, we have a question from Justice McKenna. Justice McKenna?
Mr. Collins, I don't know whether this was discussed or argued, but 651-43 says you're supposed to post 3 posting written notice in 3 conspicuous places. That if other islands also required that advertisement, would you think that would satisfy due process as on Oahu?
Your Honor, no. And the case that I think we would rely on would be Hustis versus Kapuni, where basically notice of by publication is not satisfactory substitute service when you actually know the parties that are entitled to notice. And I do believe that that's based on Mullane and other federal case law. I want to just note in terms of the statute that's an advertisement statute that's being relied on by the Spences. There are all sorts of obligations that parties have to give actual notice and give process in particular ways that are not necessarily stated in statute or rule. For example, If someone needs to be served and they live in another country that is a party to the Hague Convention, that applies. There isn't any statute that specifically says that. There's no rule that specifically says that. But if a judgment is rendered and it does not comply with the Hague Convention, but the Hague Convention should have been complied with, then that judgment would be void. And so this isn't the only instance where there's an obligation on a party to provide certain types of minimum notice to somebody, and it's not specifically spelled out in a statute or a rule somewhere.
Mr. Collins, anything further for the court?
Your Honor, I just want to note that I think without question that an execution sale that's overseen by the courts is state action. In our response to cert, we cited Shelley versus Kramer, where the result in that case could only have been, quote, secured only by judicial enforcement by state courts. And in that case, the U.S. Supreme Court found that there was unlawful racial discrimination in restrictive covenants. The U.S. Supreme Court has found by applying common law principles where the state court is required to give effect to those common law principles that state action occurs. And those cases, just a few, is New York Times versus Sullivan, 376 U.S. 254, and NAACP versus Claiborne Hardware, 458 U.S. 886. And finally, I would like to quote from Terry v. Adams, 345 U.S. 461, about state action. This phrase gives rise to a false direction and that implies some impressive machinery or deliberative conduct normally associated with orders call a sovereign state. The vital requirement is state responsibility, that somewhere, somehow, to some extent, there be an infusion of conduct by officials, panoplied with state power into any scheme by which, and then I'm paraphrasing here, citizens are deprived of their constitutionally recognized rights and interests. The state court's ability to extinguish the property interests of an individual brings into the equation state power, and therefore it is state action.
Anything further, Mr. Collins?
Yes, in closing, the WINN respondents ask this court to affirm the Intermediate Court of Appeals decision and remand this matter back to the circuit court for further proceeding.
Thank you, Mr. Collins. Mr. Munn, your rebuttal.
Thank you. I'll be brief. So Mr. Collins mentions that if he went back in time and gave his client personal notice, he would have been the successful bidder. However, as Justice Devins points out, Mr. WINN's judgment was in 2010, I believe. '13. I'm sorry. His judgment was in 2013, yet he didn't do anything for 4 years. And you have to ask yourself why. And the only explanation is because he himself got a title report and he saw these 2 senior mortgages totaling over $1 million. So for the circuit court to confirm the sale to my client, even if that was error, it was harmless error. There's no way he would have showed up at the public auction and submitted a bid.
Mr. Munn, Justice Devins has a question. Justice Devins.
Thank you, Chief Justice. Mr. Munn, here's what's a little bothersome. In the reply brief, it says the Spences earlier accused WINN of knowing about the property at 2013, yet he did nothing. WINN explained that although he had a judgment against the Bradys as of January 17, 2013, Catherine Brady filed for bankruptcy soon thereafter, and further execution was not possible at that time. It was not until September 22nd, 2016, that WINN was able to move to ratify his execution on the Brady's other property. Now, September 22nd, 16, coincidentally happens to coincide with the same date the property was transferred from Haleakala, Nohara, to the Spences. But the bankruptcy was actually lifted back in 2013. Isn't that what the record reflects?
I'm sorry, Your Honor. So
WINN is saying that they couldn't move forward until September 22nd, 2016,
Right.
which happens to be the same date that the property was transferred from Haleakala Estates and Mr. Nohara to the Four Spences. But the bankruptcy stay had been lifted several years ago, prior to that. Am I
Okay,
understanding the record accurately?
that sounds correct.
Well, if it doesn't, please correct me.
You know, I think that sounds correct. I don't know what exactly what the court may be getting at, but I will say that our judgment and our.
But what I'm getting at is the it wasn't September 22nd that they were allowed to move forward under the bankruptcy stay. That was lifted 3 years prior. But they're using September 22nd, 2016, which happens to coincide with the date that the property was transferred to the Four Spences.
So
I don't know if that was inadvertent or they got the dates mixed up, but that's what I read, and that's what was represented in the reply brief. And I just want to get clarification that maybe it was just an error or oversight.
So I believe our deed was September 22nd, 2016, and that's the same date as their motion to ratify the execution of the quitclaim deed. I don't see that same date for any other thing besides that. And the bankruptcy affected Mr. Brady's wife, had nothing to do with our judgment or our execution. We were not executing on his wife's interest at all. So the stay doesn't affect our case. And the only other point I wanted to make in response, you know, Mr. Collins points out that the ICA in a footnote said that we waived the argument of judicial estoppel. We did not. We argued it in the record. It's preserved. They even argued it before the ICA. And this court has said, of course, this court is vested with the discretion to sua sponte invoke the construct of judicial estoppel. And that's Lee versus Kuamana Community Association, 109 Hawaii 561.
Anything further for the court at this time, Mr. Munn?
No, Your Honor, I don't.
Very well. Thank you to both of our counsel for your arguments today. The court will take this matter under advisement.
Thank you.
Ua ho'oku'u ia mai ne kea aha ho'okolokolo ki'ike hanohano o ka mako aina o Hawaii. This Honorable Supreme Court of the State of Hawaii is now adjourned.